have been completely transparent that there were text messages, as opposed to emails, text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right. What's next?
So I need you to wrap it up because there's something I want to say.
Certainly, Your Honor. I'm going to wrap it up in 10 seconds.
She's going to clutch
There
some
are
pearls.
no violations of any discovery order, no violations of this court's order, and with
You
regard
create a
to the
document
retaining
giving
of
you back
ARCCA,
all the texts that
because
you don't
we're the
have,
defense,
because it's
we
usually
acted
just like, call me.
expeditiously in
It's so
response to
stupid.
the information
It's
we're
stupid.
getting.
And then
this can be tested
you get
with
wrapped
ARCCA,
for
the
it.
statement I'm going to make. To this date, ARCCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it.
At least we knew when the view was.
All these items with them. So Friday will be for ARCCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial.
Maybe in the afternoon.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I've got to talk to ARCCA and I've got to understand what they have and what they don't have. So I think, in fairness, I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you.
When's the view rescheduled?
I guess the view is rescheduled. I won't be with you, Michael, on Friday. You will be here on Friday.
Can you stay and get this?
You'll be there on Friday.
Okay. All right. Thank you.
Yeah. Okay.
She's so fast to find the violation of the defense.
She is continuing to find every reason she can to, at the very least, limit these two, Retzler and Wolf, from their testimony. Or, I don't know that total preclusion is off the table because she's now found a second intentional violation of the disclosure rules. Which she's
found an intentional violation, and she's going to find a violation of the RPC, but she's found a violation without hearing anything about what they said. They gave everything.
I know. And all they didn't do was give actual text, but a chronology and I guess a narrative. I mean, I think all of the content was given, but not the format of the texts. That's what I'm getting from it.
No, I think you go to your phone bills and you can find, you get billed for a text, but you don't have them. Like You keep all your, I don't keep my texts because I won't have any room on my phone.
Actually, I never get rid of them. So whatever are on
Really?
there, they're
Okay.
on there. Yeah. And I've never seen
Yeah.
it be a memory issue because it's such
And
tiny
and
bits
if
of
it's an
memory.
important thing, it then gets, you do it in an email. But if it's text like, are you available to talk in 10 minutes? I want to talk
Hmm.
to you about scheduling. I don't consider
Well,
those
this all
anything.
relates back to her thinking there was some underhanded communications and some misrepresentations about when the defense got in touch with ARCCA, how they may have manipulated their testimony in the first trial, how she can prevent that from happening again, if it's by some sort of sanction or testimony preclusion. That's what she's going to do, and she keeps looking for reasons to do that. So
Yeah.
now she has
Yeah.
what she thinks is a second reason to do that.